Good afternoon. Welcome to the Baylor Executive LLM in Litigation Management's Litigation Roundtable. We are so pleased today to have a distinguished panel of federal judges to talk about litigation management in the MDL process. I'm not sure we've ever had the panel had a distinguished transferee judge and then a judge with Judge Ferguson's breadth of background and experience before. We recognize that our audience today has people with tremendous experience in MDL litigation, as well as people who are fairly new to MDL litigation. As always on our webinar, we encourage you to submit questions for our panel in the chat. And don't be afraid, if you are new to the process, send it on. There will be others in your shoes as well. And if you are more experienced, here's your shot at Judges Caldwell, Proctor, and Ferguson. Let me give you brief background. Judge Karen Caldwell sits in the Eastern District of Kentucky. She was confirmed by the Senate in October of 2001 and then commissioned. She was experienced as a member of the Kentucky Board of Bar Examiners, the Bench and Bar Magazine. She had an extensive litigation practice, was an adjunct professor at Eastern Kentucky, assistant U.S. attorney for the Eastern District. In short, Judge Caldwell has seen the litigation process from all different perspectives. Now, of course, she serves as the chair of the judicial panel on multi-district litigation, and you'll hear more about what that means. Judge David Proctor is a judge for the United States District Court for the Northern District of Alabama and has held that bench since 2003. Don't be fooled by the mild-mannered exterior. He played varsity football in college while also being a public defender, which is very fun. He graduated with honors from the University of Tennessee College of Law, where he was on the law review, the court team. He had a labor and employment practice for many years before taking the bench, and is very active now as one of the preeminent transferee judges for multi-district litigation. Finally, it's my privilege to introduce our dear friend, Judge Royal Ferguson, who is a retired judge for the United States District Court for the Western District of Texas. He also served in the Northern District before he took senior status. He has been a practicing attorney. He is board certified. He's a fellow of the American College of Trial Lawyers. He's a member of the American Law Institute. He served as dean for the University of North Texas Law School, and he too brings a breadth and depth of experience and information about this. Judges all, we could not be happier to have you here today or more appreciative of your time. Judge Ferguson, let me hand it off to you to get our panel going.
Thank you very much, Professor Fraley. Thank you so much. And I'm delighted to be here with the people at Baylor Law School and with my two very distinguished panel members. One thing, Professor Fraley, you did mention Judge Proctor's athletic accomplishments. I do want you to know that I played basketball at Texas Tech through my sophomore year. But then my coach came to me at the end of my sophomore year, put his arm around me and said, I don't think you have any future in college basketball. I would suggest you work on your grades, which I did. So at any rate, David, you probably spent a little more time on the athletic field than I did on the basketball court. But that being so, at any rate, it was short-lived. I
guess career. One bench's loss is another bench's gain.
Well said. Really, my role here will be to give a little bit of an overview about the federal MDL panel. For those of you who are watching, let me recommend to you a wonderful law review article that you might refer to get really a detailed overview of the panel and its work. It's in 82 Tulane Law Review, page 2225. That's 82 Tulane Law Review, page 2225. It's written by John Hayburn, who, when he wrote it, was chair of the panel, and it's entitled "A View from the Panel, a Part of the Solution." I think you'll find that law review article helpful if you don't have it in your list of authorities. As you know, the MDL panel is created under 28 USC section 1407. The legislation creates 7 panel members, now sort of by Supreme Court Chief Justice rules. The 7 members serve 7-year terms. They all must be from different circuits. Most of the members of the panel come from the district bench because that's where the heavy lifting occurs in the work of the transferee courts. So that's just a basic overview, but of course, always have 28 USC section 1407 at your fingertips when you're thinking about the panel. The panel always answers 2 basic questions. First, whether common questions of fact, not law, but whether common questions of fact among several pending cases, civil cases, exist so that centralization in a single district will be best for everyone considered. So there must be common questions of fact existing across several civil cases. And second, if the answer is yes to the first question, then the second question is which federal district and federal district judge are best suited to handle the case. And today, we really couldn't have 2 better people to sort of address these 2 big questions than the chair of the panel, Judge Caldwell, who has such a distinguished career and is leading the panel in such a distinguished way. And then to have David Proctor, who has also served on the panel, and during my term as the panel was considered one of the very best transferee judges in the system. I've always thought that the judges who were assigned transferee cases are like the fighter pilots of the federal courts. They're the people who really have shown through their work that they have the aptitude and skills necessary to do the heavy lifting that's required in MDL litigation. So with that sort of overview, I wanted now to turn the matter over to our chair of the panel, Judge Caldwell, for her to give you her take on the panel. Judge Caldwell.
Thank you, Judge Ferguson. It's an honor to be here with you, Judge Proctor, and all the folks at Baylor, and all the folks who are attending this conference. Just to follow up on what you said about 1407 and the panel's ability to centralize one civil actions pending in different districts, I think it's very important to note that the panel may transfer cases to any federal district in the United States, even if the transferee court has no personal jurisdiction or venue, and whether or not the transferee court has any of the cases pending on its docket. So that's something very important to remember, and is becoming more important in the days of technological tools of litigation. I thought first I'd talk a little bit about the kinds of cases that come before the judicial panel on multi-district litigation. Then I'll add a little bit to Judge Ferguson's description of the panel and its role. And finally, I think I'll get to the process of centralization and case assignment, which seems to be the question that I get most from practicing lawyers and judges. As I said, the statute permits centralization of any federal civil action as long as the requirements of 1407 are met. Very few actions are excluded by the statute. In fact, I think that the only two that I can think of are antitrust cases filed by the United States and injunctive relief actions filed by the SEC. Otherwise, it's fair game for centralization. The types of cases that we currently have in MDL cases involve intellectual property, employment cases, pay equity cases, financial fraud and mismanagement, data breach and security cases, but by far the largest number of cases that are consolidated into MDLs involve mass torts. As a matter of fact, 33% of all MDLs involve mass tort products liability actions. Presently, we have pending in an MDL in the Northern District of Florida, the largest MDL ever. The brave soul, Judge Casey Rogers, has pending before her 229,000 cases in the 3M Combat Arms Earplug Products Liability litigation. This MDL alone represents 39% of the entire current federal civil docket, and it's 64% of all multi-district litigation cases. So I think you can only imagine if all, in that one case, if all of those cases came into the federal civil judicial system, it could pretty well grind it to a halt, in addition to causing all sorts of inconsistent results in courts pending all over the United States. As a percentage of the entire federal civil docket, multi-district litigation cases contain 60% of all cases currently pending in the federal civil judicial dockets. Now I'll break it down just a little bit. As Judge Ferguson pointed out, the panel consists of 7 judges from 7 judicial circuits, all appointed by the Chief Justice of the United States. We operate administratively just like any other court. The panel has a set of rules. It has automatic case filing. It provides resources for MDL judges, training, and it also provides resources for practitioners. I encourage all of you to visit the panel's website. That's www.jpml.uscourts.gov. There you'll find a wealth of information, not only about the panel, the rules of practice, some of our opinions, many of the statistics that address the number of cases that we have. It provides a wealth of information. Judge Ferguson also pointed out John Habern's Tulane Law article. That's very helpful. I encourage all of you also to consult the Federal Judicial Center's manual on complex litigation, which is a tremendous tool for anyone engaging in MDL practice. In addition to an administrative staff, the JPML has a general counsel. We have law clerks who help the panel prepare for its hearings. That staff, though, the general counsel and her staff, they also provide assistance and information to transferee judges and to practitioners who have questions of them. Now, as Judge Ferguson already pointed out, the primary purpose of this panel is to decide whether cases should be centralized, and if so, where and before whom. The panel also decides whether to transfer tag-along actions and whether to remand cases back to the transferor or court. But otherwise, the panel has no role in managing the MDL litigation. While we provide training and support to transferee courts, we do not, and we have no authority to direct the activity within the transferee court. In 2020, we considered 53 motions for consolidation and granted 26 of those motions. So it's not to be taken for granted that the court will, or that the panel will, consolidate. In fact, we look at centralization sort of as the last alternative, and I'll talk a little bit more about that in a minute. But let me say this, that 2020 has been a very unusual year for courts all across the United States, and the JPML is absolutely no exception. We normally travel every other month to locations throughout the United States to conduct hearings on motions for consolidation. As you know, because of COVID-19 restrictions, the panel has been conducting its proceedings virtually. We hope by the end of this year that we will resume our in-person panel hearings. And although it's been imperfect, we have kept the wheels rolling, so to speak, in terms of managing the work to come before the panel. As I said, we hope to resume to normal practices probably by the end of this year, when the state's restrictions on travel have eased, so that parties and panel members can travel safely. Now let me get to the heart of the matter. Most groups like this are interested in the panel's decision-making process on the issue of centralization or appointment of the transferee court. Let me just say, as I mentioned a moment ago, that the premise is that 1407 is the last solution after considering all the other options. Primarily, we want the parties to consider whether informal coordination or whether a 1404 voluntary transfer is an appropriate measure, something short of an MDL. And as Judge Ferguson noted, there only need be one common question of fact. Only one, but of course, often there are multiple questions of fact that require the transferee judge to maybe address different tracks, address these issues on different tracks for discovery. Things that the panel considers in making its decision. I'll mention a few things, but this is not an exclusive list. First of all, we look at the party preferences. Very often the parties come to the panel with an agreement on whether the matter should be centralized, with the only disagreement being where the matter should be centralized. So we can consider the parties' preferences. We look at whether there are forum selection or arbitration clauses. We look at the status of various cases that have been filed. Are some newly filed cases, or are others advanced? We look at the location of the parties, witnesses, and evidence in the case. That may be less important in the future, and we'll talk about that in a minute. But are the plaintiffs different? Are there multiple defendants? What's the number of actions? And what are the conflicts of law? In other words, we look at a number of factors to determine what makes sense under the circumstances of this case. Who and where is the matter transferred to? Well, let me take them in reverse order. Where is becoming a more interesting question in light of technological advancements. It once was that people came to the panel arguing, well, the witnesses, evidence, and parties are in a particular location. That's where the center of the litigation is going to be. So we need for it to be transferred to that particular district. Well, that's becoming less important with electronic discovery, with tools like Zoom that we're using now. Location is less important, but it is still very relevant. And as I pointed out a few minutes ago, the cases can be transferred to any district in the United States, even if there are no cases filed in that district, or if the district court lacks jurisdiction and venue. Remember, the statute provides for transfer for pretrial consolidation and coordination. The next question as to where involves whether the parties make a recommendation or they have a preference. Many times they do, many times there is an agreement, and the panel takes that seriously. In considering where, the district to which the matter will be transferred, we look at the docket conditions of the transferee district. We look at where the cases are filed, where are the most cases filed, and again, the location of parties, witnesses, and evidence. As to who, which judge, we look for three basic characteristics. We look for interest, expertise, and capacity. Interest We don't want some reluctant judge to take on an MDL. I mean, would you be interested in taking on additional work for which you receive no compensation or a reduction in your caseload? Really is the first and most essential question. So we need interested enthusiasm. We look to the judge's expertise, their litigation experience as a lawyer and a judge, prior MDL experience, their length of time on the bench, and their experience generally in complex litigation. We also look at their capacity. Is this judge already overworked? Of course, sometimes if you want something done, ask a busy person. But nevertheless, we look at the judge's capacity to take on additional work. There is no magic formula here. And you may ask, how do we glean this information from all the judges? Each year, the panel sends out a survey to every district judge in the United States, asking the very questions that I just identified, asking about the judge's interest and their experience, to tell us, would they be willing to take a big MDL, a small MDL, to give us a glimpse of their prior experience. So we have all this information at our fingertips. Then we also have, as members of the panel, very active judges like Judges Proctor and Ferguson, who know people in the community, who have handled litigation themselves, who understand the needs of this particular litigation. And they assist us with their personal knowledge in terms of who, where, and how this case should be transferred. I'm going to wrap up here, but let me mention one thing that I think is very, very important. Judges must be creative and aggressive in managing complex litigation, whether it's an MDL or any other kind of federal civil case. By keeping the docket moving and keeping the pretrial matters in the forefront, you get a case ready to settle or proceed to trial. And that is the goal of the MDL panel. We do not assign a case with the admonition that the judge must settle it. Many of the cases in MDLs do settle because these judges work hard upfront at managing the pretrial practice, which is the purpose of an MDL. I hope I have given I know it's a very brief overview, but I want everyone to hear from the judges who have handled these cases. And from my perspective, my colleague on the JPML, Judge David Proctor, has wonderful experience. He was a great colleague as a member of our MDL. He just retired. And I really miss his insight and his experience as a panel member. But more importantly, I appreciate his experience and his generosity as an MDL judge who not only handles his own cases masterfully, but he is generous with his time and assisting other new MDL judges in their cases. So let me turn it over to David Proctor.
Thank you, Judge Caldwell. And thanks to Baylor. This is a magnificent program, the LLM program, just researching it. And I do appreciate them taking the time to devote attention to this area. You know, I'm on this panel with Judge Ferguson and Judge Caldwell, and I'm reminded of my first day I walked into a conference room with my panel judges that I was newly appointed. I looked around, and this is in honor of Judge Caldwell from the Bluegrass State. I felt like a mule who'd been entered in the Kentucky Derby. You know, I don't know if you heard the story, but the promoters finally came down to the starting gate. The mule had been put in gate number 3, and they stopped the start time, and they told the promoter, told the owner of the mule that we can't let you run your mule in our race today. And the owner of the mule said, well, first, I figured you'd eventually say that. And second, I didn't think he would win. But third, I thought the exposure would do him some good. So I feel like I am getting some great exposure being sandwiched between Judge Ferguson and Judge Caldwell today. I don't want to take a lot of time on this because I know you want to hear more about transferee judge work, but I just want to extend the personal privilege of discussing both of them a little bit. First, Royal was one of my mentors, is one of my mentors. You know, it's every once in a while you're in the right place at the right time and make the right friendship. And that was certainly the case with Judge Ferguson. I got to know him at the Breakers, doing some MDL work, and he was just exceedingly kind with me, taking me under his wing, teaching me things, introducing me to the right other judges who could really have an influence on how I proceeded as a brand new transferee judge. And Karen is my captain. She took over the panel after two very distinguished other folks that I think Judge Ferguson served with, both Judge Hayburn, who he referenced earlier, and Judge Vance from New Orleans, Eastern District, Louisiana. And she, you know, was immediately met with a lot of new faces showing up on the panel. I think since she's been on, 2 new judges have entered the panel each year. Whereas before her time, I think we had a 5 or 6 year stretch with continuity of each judge still serving. And if that wasn't enough, she got hit with the COVID-19 pandemic and just captained us through that process with aplomb and strategy and adaptiveness. And I just can't express enough thanks to her for that. So let me review some quick nomenclature for MDLs, just so we'll define a few terms as I use them. We all know what the panel is. Judge Caldwell and Judge Ferguson have kind of explained that to us. The transferee court is the court that receives the centralization once a case is centralized and it's sent off by the panel. That is the court that receives all the centralized cases, so the transferee court and the transferee judge. The transferor court and transferor judge are the judges and the courts from which the cases proceed. That's where they were originally filed. And whether they're on a motion for centralization or tag-alongs, they would proceed to the transferee court, but the original forum would be the transferor court. And a tag-along is simply a case that fits the definition of a centralization motion. It would have been centralized on the motion if it had been around at that time, but it's subsequently filed, so it tags along. There's a process the panel uses for determining whether or not something gets centralized after the fact as a tag-along. The case may be subject to a conditional transfer order. The staff makes a call on whether it recommends centralization or not, but the parties have an opportunity to be heard, notice and an opportunity to be heard on that, object to it. And then at its next regularly scheduled meeting, the panel would decide whether or not that case ought to tag along or stay where it is. I say all that because I'm going to be using these terms somewhat and discussing what a transferee judge does. So when it comes to MDL, multi-district litigation, I have had 4 perspectives over time. The first is as a practicing attorney. I think it was mentioned earlier, I was a labor and employment attorney. So in that perspective, it was multi-district litigation. What is that? I had no idea. Then I was a brand new district judge a couple years after Judge Caldwell went on the bench, and she probably had this experience too. All my colleagues got to give me 38 cases that they thought I might find interesting. And that means they walked in the door on all 4s, barking the whole way. But every once in a while, I'd get this notice from the panel saying that a case of mine was being transferred off to some other district in the country as part of this multi-district litigation centralization. And I thought, okay, multi-district litigation, I like this. I have 1 less case on my docket. Then I became a new transferee judge, and I started getting a little bit of a perspective on what's involved. As I said, Judge Ferguson and Judge Fallon from the Eastern District of Louisiana and a few other folks just were so generous with time and resources to kind of bring me along. My first assignment was the breast implant litigation. And I used to joke that Judge Pointer, Sam Pointer from our district, had that initially when it was filed. It's a very interesting story about how he got it. Apparently, the two leading districts at the time that were thought to be the front runners on where it would end up were in California and Ohio, where most breast implant consumers and manufacturers were. The competition for that assignment got to be so rancorous and so problematic that the panel said, look, we have judges in both those districts that could handle this well and with great dexterity, but to avoid that type of rancor, we're going to assign this case to the Northern District of Alabama and our former colleague, Sam Pointer. So I used to joke that, and Pointer did some amazing things. He was kind of a pioneer in the 90s when it came to multi-district litigation. It was fairly new still at that time, just 20 years old or so, 30 years old. And he really did, had a lot of innovations that we still use today and still look at today as just great techniques for handling cases. And I used to joke that, you know, the panel wanted to see if Sam Pointer did such a good job putting that litigation in place that even Proctor could close it. And I eventually did, finally got it closed down. And then I got my next case was my own from the beginning, a little small total body solutions MDL products liability case, small case, but I coordinated with a state judge who had more cases than I did based on a non-diverse defendant being over in Georgia and the cases were not in federal court. And then eventually my fourth view was as a panel member. I actually got to climb up in the air traffic control tower, see how this works. And I thought Judge Caldwell just did an excellent job of giving you exactly that, a air traffic control view of how we get the planes on the ground and off the ground and what we do in between. I want to commend one other article to you if you're interested in this area, and I'm going to refer to it as we move along. It's by a professor at Cal Berkeley Law School, Bolt Hall, named Andrew Bratt, B-R-A-D-T, and the name of the article is A Radical Proposal, the Multi-District Litigation Act of 1968. You can find that at 90 Pennsylvania Law Review, 831. It's a 2017 article, if my memory serves me correctly. And in that article, Professor Bratt takes on academia. Now, I think the Baylor LLM program is very practical and academic, and I commend them. Not, as it turns out, though, if you're not majoring in litigation management or teaching it or administering it, you're at another school that probably isn't as competitive as Baylor, and you're trying to get tenure. You don't get tenure by writing an article about how great something that Congress has put in place works. The way you get tenure is to find a nuanced area and write about it and criticize it and critique it. And to be honest with you, some of the critiques we've got in academia are quite good. This is art, not science in a lot of ways. There's no, one size does not fit all. There's different ways to approach things. We make mistakes as we handle these cases, as you would expect we would. The parties make mistakes from time to time as they handle these cases, as you expect they would. But what I think it does, and I'm going to steal this from Judge Fallon, it really gives you an opportunity to get the best problem solvers in the world before you and assemble them and tackle problems. And, you know, that so I think the academic criticism we get and from some corners is quite helpful. It really causes us to come back into the tent and think about what's being said. I would like to tell you that all the academic criticism that the process has gotten is on that same plain, but it's not. Some of it just doesn't make any sense, and it betrays kind of a lack of experience, I think, quite frankly, with multi-district litigation and how things work. Here's the thing that Bratt's article does. It defeats this whole premise that permeates some of the academic literature, some of defense lawyers and big laws views, and some small plaintiff firms views that the multi-district litigation statute was this meager proposal to deal with a small segment of litigation, and that it's metastasized beyond any proportion of what Congress intended to be in 1968. That simply just isn't true. The preeminence of multi-district litigation is not a product of dumb luck. It's a realized ambition, and I'm stealing from Bratt here. I'm going to summarize some points in his article. The small group of scholars and judges who invented MDLs and the multi-district litigation machinery shepherded it through enactment in Congress when it was not a slam dunk that it was going to get through back in the late 60s, did so because they perceived as early as the 1960s and early in that decade, a rising increase in the prevalence of mass torts and litigation explosions. They had a pretty good bellwether on that, and that was in the early 60s, there was a great amount of antitrust litigation over price fixing allegations in the electrical equipment industry. And the old committee, which was called the, I'm trying to get this term right here, the committee on the coordinated committee on multiple litigation, which was kind of a precursor of the panel, was chaired by Judge William Becker of the Western District of Missouri. And the executive secretary was a University of Chicago Law School professor named Phil Neal, who eventually became the dean at University of Chicago. I'm partial to Chicago a little bit these days because I have two clerks from Chicago and they tell me how wonderful it is. I'm going to tell them they need to go get their LLM at Baylor now. But they had some help. They had Judge Murrah from the 10th Circuit. They had Judge Robson from the Northern District of Illinois. And this small group came together and put together this idea that was going to really address the best way to handle this explosion in litigation. The judges believed deeply that control of these cases should not rest with the parties and counsel, or even in the hands of federal judges scattered throughout the country individually handling these cases, but that a single judge ought to be brought in to handle the litigation in a centralized fashion. Now they realized that there was going to have to be some restriction on power for a transferee judge. The venue and other issues were going to permeate the discussion about whether to pass this statute. So they put some limitations in place. Transferee judges do not try these cases unless they are originally filed in the district or are transferred to the district through a different statute, for example, 1404A, forum nonconvenience. Now, a footnote to that. For a while, transferee judges had the idea, well, we can try these cases if we will transfer them to ourselves under 1404A. So the case comes into our district under 1407, and we can retransfer it to our district under 1404A in a case called Lexicon. The Supreme Court said, no, we're not going to do that. So let's talk about what 1407 transfer looks like when the panel sends it along and we receive it in the transferee court. The first thing you need to know is that each case keeps its individual character. This is not like a class action where we merge all these cases together into one. Now, practically speaking, there may be some techniques we can use to have the cases centralized and put in a workable pattern for us. We can require a master complaint be filed that will be filed and will help us manage the case and join the issues in the multi-district litigation. Obviously, sometimes a transfer of cases into a transferee court involves class actions. In fact, my Blue Cross Blue Shield antitrust litigation started off with somewhere just south of 100 different class actions that were transferred into our court or filed originally in our court. I think we're down to about 18 or 19 of those still, but each one of them keeps its individual character. It's a separate class action filed involving a particular market, filed originally in a particular district court that the panel centralized and sent along for coordinated treatment. So these cases are not joined in the sense that the parties are all part of one case. They're centralized in the part that they're all in one district for coordinated litigation. The second thing is just understanding the efficiencies that Judge Caldwell referred to and Judge Ferguson referred to. Those play a straightforward role in terms of what a transferee judge is going to try to accomplish once the transferee judge receives the case. So let me give you two scenarios that might help appreciate some of the friction that a transferee judge might deal with right off the bat when these cases are transferred in. First scenario is a hypothetical. Assume a defendant is sued in 51 districts, which reside in 33 different states in relation to its manufacture of a product on the markets. In each district, it's required to produce the same documents related to its manufacture and retail of the product. It's testing of the safety concerns about the product. It's the efficacy of the product. It's required to answer the same or very similar interrogatories in each one of those districts. It's required to hire or oppose the same experts or types of experts in each one of these districts. And it's required to put up the same deponents and perhaps depose the same third-party witnesses who have knowledge about the product, separate from these particular plaintiff's claims on either a general causation issue or some other issue related to the product generally. All right. So you can imagine, as Judge Caldwell was talking about in the case before Judge Rogers, down in the Northern District of Florida involving the 3M earplugs, that would really grind a lot of courts to a halt, because each one of those is dealing with thousands of cases, but also each one of them is going to have to replicate and duplicate all these efforts in discovery and in motion practice. All right, so it makes sense that we would want a process where we're not there. Okay, second scenario. Assume Susie Johnson lives in Topeka, Kansas, and she's been affected by that product. And she goes to a lawyer on Main Street in Topeka. He files a state court action alleging that the product is unreasonably dangerous under Kansas law. A couple weeks later, he gets a notice of removal. The case has been removed to federal court. And a week after that, he gets this strange motion that's been forwarded to him by this Washington group called the Judicial Panel on Multidistrict Litigation, saying that he is set for oral argument next month in Phoenix, Arizona. And the question that they're going to decide is whether to centralize the case or send it to the Northern District of California and send it to the Northern District of California. Then he finds out through briefing that there's some other groups that want it centralized, but they want it sent to the Southern District of New York, the Eastern District of Pennsylvania, the Middle District of Florida, or the Northern District of Illinois. Susie wants her case tried, and she's going to have to get in a line with other plaintiffs to work through some of these issues in whatever case, whatever court it ends up in to do that. All right, so What do you do early on as a transferee judge? Well, you got to get control of the case. You've got to get a handle on what the case involves, and the best way to manage the case to get to the end of the centralized litigation that needs to take place. That might involve an early case management order, selection of leadership, counsel on the plaintiff side, or maybe the defense side, if there's multiple defendants, to have one voice speak and work your way through the program of figuring out how to do this, identifying key discovery issues, motion practice. You may have to deal with financing the litigation. Parties need to have money to prosecute these cases, and you might end up having to coordinate with state courts. I've got some other thoughts, but I think, Liz, you're interested in maybe opening up to some questions or getting this into more of a discussion format. So I can hold the thoughts about more specific things that happen, problems that arise, opportunities that arise, until we get some of those questions.
Perfect, Judge. And again, let me encourage you, if you have a question and haven't already popped it in the chat, go ahead and put it in. Give us the insider's view. What are your pet peeves when people appear before you? And you've all had different levels of experience with this. How can they do a better job for their client? And specific to our topic of litigation management, how can you more effectively manage litigation in the MDL format? Brief thoughts from everybody.
This is basically at the transferee level, correct?
Yes.
Okay.
Well, I'll lead off then, since I spoke to the transferee cases, but I would welcome Judge Caldwell and Judge Ferguson, who I think also have a great perspective on these issues, to join in as they see fit. So what am I expecting? Well, the first thing you shouldn't do is show up and start immediately talking about how you want to get Susie Johnson's case back to Topeka, Kansas. And it's really unfair for you to be here because you didn't ask for this, don't want it, and shouldn't be subjected to it. Unfortunately for you, Congress has made a decision back in 1968 that we're going to prioritize these centralization issues because that is the most efficient way for the courts and most of the parties to do it. So we sacrifice individual efficiency for group efficiency. It's an economics, maybe not a financial economics, but an economics quotient there perhaps. So that's the first thing that you should understand is, okay, you're here, we're gonna have to make the best of it. So if you're interested in getting your case back to Topeka, Kansas, then the most productive thing you could do is to contribute positively to a plan to get these centralized issues litigated as appropriate decided, and get the cases where they are ready to go back to the transfer court. By the way, Judge Caldwell would be quick to point this out. I can't, as the transferee judge, remand your case back to the transfer court. Now, I can do some other things. If you were out there on a removal like Susie Johnson, I get to decide remand questions to state court because the transferee judge steps into exactly the shoes the transfer judge would have on pretrial matters. I can rule on discovery matters. I can rule on Daubert issues. I can rule on 12B6 motions. I can rule on 12B1 motions. I can rule on remand motions after removal petitions been filed from state court. But I can't send you back to the transfer court. Only the panel can do that. One of the criticisms is not many cases get remanded back. I think the statistics is 3% of the cases get remanded back, and some of our less informed critics of the MDL process point to that and say, aha, these are roach motels. They go in, but they never come out. Well, I would ask you to think about this. Why do we remand cases back? If we've handled all the pretrial proceedings, it would be for trial. These cases are ready to be tried. So I'm Judge Ferguson, that was the transfer judge, let's say, in Lexington, and this case made its way to me. It's ready to be tried. I sent it back to Judge Caldwell for trial. What percentage of cases try in the federal court system these days?
Tiny.
Yeah, probably less than 3%. So I think I've heard 1% on some recent studies. I don't know that anybody knows exactly the number, but if it is 1% of the cases go to trial now, they don't settle, they don't go out on dispositive motion, they don't go out for some other reason, and they actually make it to trial. That means the panel is remanding back 3 times more cases than we'd expect. Because often what happens is when a transferee judge completes all the global issues, even if that is not all the discovery and motion practice that needs to be had to occur, and there's individual motion practice in each of the cases, or individual discovery that's specific to those cases, that would be an appropriate time for me to suggest remand to the panel and for the panel to send it back for other pretrial proceedings in the transferor court.
Judge Proctor, you were talking about the trial aspect, but one of the questions that we've had is about the increasing trend, especially in product liability MDLs, with piecemeal settlements rather than global settlements. Judge Ferguson, Judge Caldwell, what do y'all think about this piecemeal settlement trend? Is this a good thing? Is this a bad thing? What do you think about that?
I'll since I'm not on the bench anymore, I'll yield to Judge Caldwell, but I'll if I need to respond, I'll do so.
There you go, Judge.
You know, I think you have to look at these cases in a highly individualized context. You know, trends and NDLs are kind of dangerous things to look at. You've got to look at the number of factual issues in dispute, the number of parties, the kinds of cases. I am reluctant to say whether that is a good or bad thing. I do think that as lawyers and judges, we all prefer to have a global settlement of a case so that it can be finally resolved. I mean, that is the most efficient result, but is it the most just result? And I think that that is a question that we can't answer unless we're looking at the facts of a particular case. And let me add on to what Judge Proctor just said. I was looking at a number of different surveys here from the ABA and others that 90% of all civil cases settle. So what you're looking at is that the MDL settlement rate is about the same as all civil cases. So there's not a remarkable difference there. But I do think that that there is a general preference for global settlements, but I really can't identify a particular factor that has caused this recent trend. Judge Proctor, do you see anything that I don't there?
No, I don't think I see anything you don't, but I'd further point out that, again, each of these cases maintains its individual character. And if you're a lawyer in Topeka, Kansas, I keep using that analogy because I think it takes it out of the abstract and puts it in the concrete. If you're a lawyer in Topeka, Kansas, representing Susie Johnson, you have the right to come into that multi-district litigation and talk directly with the defendant about settling your case. So it should not surprise us that we get settlements. After all, I would expect that a corporation facing major exposure with a group of products liability claims is more likely to decide not to bet the company bank on that trial than would be a garden variety Title VII case that they might be defending, or a breach of contract commercial dispute that they have with a vendor. So if anything, I would think settlements and MDL, just from a common sense standpoint, would be more prevalent than settlement of your garden variety cases that aren't centralized. And then the other thing is you got really good lawyers in multi-district litigation. We have a bar that just is exceedingly talented, well-versed. just going back to what Judge Fallon said, the greatest problem solvers in the world, we unleash on these problems. And my view is I need to keep a firm hand on management of the case and keeping us pointed north in terms of the progress of getting the case worked through. But there are certain areas that I just need to get out of the way of the lawyers and let them do their work and accomplish some results that they are going to be fully capable of pulling off without my micromanaging in some ways. One of the big issues right now on rules is, should there be a rule about the transferee judge's role in settlements of multi-district litigation? I know that the subcommittee for the civil rules on multi-district litigation rules has looked at a number of rules proposals in that area, but also in the area of initial case census, interlocutory appeals, third-party financing, and they're looking at the settlement issue. Now, I think they've kind of backed away from rules on those other three areas, but they're studying settlement right now. And so what should be the transferee judge's role in settlement? And with that, I will defer to some of my more experienced, wiser friends on the panel and see what they think about that.
Well, I think from a panel perspective at this point, and we're still in the process of listening and discussing with the Rules Committee and various organizations, but, you know, I think that each MDL case is kind of a blank canvas, if you will, and as Judge Proctor's described, what we try to do is give the judge, the act does actually, is to give the judge the discretion to handle this case in a way that fits the needs of the parties and the cases. And the more restrictions you impose on that, the more constraints that are put on the judge, it makes it more difficult to achieve the purpose of the statute. When it comes to the involvement of judges in the settlement, this is an important area where we must distinguish the multi-district litigation from the class action, where a judge has a very active role in supervising the settlement of the case. Again, these are a collection of individual cases, sometimes even a collection of class actions. So I think right now, and I can give you my opinion, I can't speak for the rest of the members of the panel, but it seems like developing best practices seems to be a way of putting things out for discussion, some guidance for judges and parties without imposing the restraints and constraints on courts that need flexibility in resolving these cases. And let me add one other thing, it's a little bit off topic, but one of the things that Judge Proctor mentioned, you know, what a talented bar we have practicing in this area. We also have talented judges. One of the things the panel wants to do is we want to increase our depth. Baylor's a basketball school. I'm from the University of Kentucky. That's a basketball school. So we want a deep bench. We want a deep bench of practitioners and a deep bench of judges. And we have networks of people who reach out to one another, who help each other, but we're really looking at ways of being more inclusive in the kinds of judges, the geographic regions that we're choosing, the race and ethnicity of judges, gender and things like that. We're trying to be sensitive to that in making our decisions. Also, I think one of the things that we're communicating to transferee judges is to be sensitive that we need to give more members of the bar the opportunity to participate in leadership, to take on an increasingly large role. You know, when you depend on the starting team, if somebody fouls out or has a problem completing the game, then you find yourself a little short when you come down to the wire. So those are some issues that we really don't have firm rules on, but let me just say that we are sensitive to these concerns.
Can I say
You
one
don't
thing
want all
about-
your seniors to graduate either.
That's right.
Right. The issue on settlements, an interesting issue. Another issue that's related to that is the bellwether trial concept. And I think that concept probably needs to be subject to some rethinking. I've seen over the years that it hasn't seemed to do what you wanted it to do, is to sort of bracket the numbers and help you think of where settlement should be. I think bellwether trials are a concept that needs to be looked at.
No, Judge Ferguson, I totally agree with you. I think bellwether is a tool in the toolbox. But if I am trying to change my tire, I need to get a lug wrench out. I don't need to get out a chainsaw or a hacksaw. And I think sometimes for a while there, I think the parties and some transferee judges perhaps thought that the thing you do is you handle your discovery, you do some motion practice, and you set a few of these cases for trial and try to kind of see how things work out. I've never conducted a bellwether in any of the cases I've handled. Now, in the Blue Cross Blue Shield litigation, we did something a little bit unique. We had bellwether. I said, let's do bellwether litigation. I had antitrust cases from all over the country filed. And I said, you know what we're going to do? I have some authority, more beyond my 1407 powers, to handle the cases that were directly filed in front of me in Alabama. And at least on the motion practice front, we're going to push some of those motions out in front and maybe bellwether some results on how things work out on things like standard review, whether or not the filed rate defense might work, a number of other things like that we're going to have to be applied across the board in a little different context. So we use bellwether litigation, and I think the parties were a little, some of the parties were a little hesitant about that early on. I think that over time, they understood the effectiveness of this. Now, that doesn't mean they always agreed my rulings on those matters, but they understood the need to tee those things up and get rulings.
Well, I want to just add one thing too, that our discussion, and it always tends to trend toward the mass tort, because that's usually where you have the most parties and the most different districts involved. Remember that in many cases, we have as few as 5 plaintiffs in an MDL. So they can range in size from 5 to 50,000, 200,000. So it's very important to note that this is not a one-size-fits-all analysis. And I think lots of times when you talk about piecemeal settlements or you talk about bellwether trials, those tools are more useful depending on the size and nature of the case. And we can't forget that there's 60% roughly of the MDLs that don't fall into this mass tort category.
That's a great point. And I knew when we scheduled this webinar for only an hour, we were probably shooting ourselves in the foot. But it has been an hour well spent with our distinguished panel. Great insight. I can tell you, as both a practitioner and a professor, hearing it directly from judges really does help crystallize some of the practice points. For those of you who want more information and experience in litigation management, who want to be handling these complex matters, or who just want a reboot of your practice, we encourage you to look at our LLM. I think it's easy to say that it can really make a difference in how you approach litigation. We appreciate your joining us for today's webinar. The CLE information was posted in the chat. And thank you, Judge Proctor, Judge Caldwell, Judge Ferguson, for your contributions. Have a great day.